This conference will now be recorded.
Good afternoon, dear members, industry colleagues, and respected speakers, and a very good morning to our members and colleagues in Germany. A hearty welcome to all of you for joining today's web seminar on drafting engineering contracts to avoid disputes, organized by the German Engineering Federation, VDMA, in association with BTG Legal. We hope all of you and your family and colleagues are safe and doing well. I'm Jamri John, based out of the Mumbai office of VDMA, and I'll be taking you through the session today. Before we continue, we'd like to keep you informed that the web seminar is being recorded, and this is just for your kind information. We request all the attendees to kindly keep your microphones muted and cameras switched off at all times. You could continue to post your questions during the entire session under the chat box, and we'll be taking it up during the last leg of the web seminar during the Q&A. Next slide. VDMA is committed to India. VDMA, the Mechanical Engineering Industry Association, was founded in November 1892 and continues to be the most important voice for the mechanical engineering industry. VDMA represents around 3,348 mostly medium-sized companies, making it the largest industry association in Europe. The members are currently contributing to 78% as exports, which is equivalent to 205 billion euro production. Recognizing the very early significance of India as a future market for our member companies, India was one of the first overseas offices among the BRIC countries. VDMA is the only German industrial association having well-established offices in India since several years, with our presence currently being in Noida, Mumbai, and Bangalore. Next slide. For today's web seminar, we will have the welcome address from Mr. Rajesh Nath, Managing Director of VDMA India, and this will be followed by the presentation on engineering contracts by Mr. Prashant Mara and Mr. Parveen Arora, who are both partners at BTG Legal. We will then conclude with the Q&A session. Next slide. Mr. Nath has over 3 decades of working experience in various industries, both in Germany and India, and has been the face of VDMA for more than 2 decades. He has also been accorded the Cross of the Order of Merit, which is the highest civilian order from the German president for promoting Indo-German trade in the engineering sector. With no further delay, I'd like to hand it over to you, Mr. Nath. Thank you.
Yeah, thank you. Thank you, Jamli, and good afternoon to all our members from Germany and India, and also friends from the Indo-German fraternity. A hearty welcome to all of you to this web seminar today on a very pertinent and relevant topic, drafting engineering contracts to avoid disputes, being organized by German Engineering Federation, VDMA, together with our eminent partner today, BTG Legal. I extend a warm welcome to our speakers, Mr. Prashant Mara, partner BTG Legal, and Mr. Parveen Arora, partner BTG Legal. In fact, we feel privileged that BTG Legal would be using the VDMA platform to release and they will also share with all the participants a playbook on EPC contracts covering many important aspects, including guidelines on formulating contracts and how to avoid disputes. Friends, an engineering, procurement and construction EPC contract typically includes design, engineering, supply of goods and services, and such a project may be on land, onshore, or it may be on sea, offshore. Being huge and complex infrastructure projects, EPC projects generally take long to conceptualize and implement. Due to this long gestation period, including size and scope of the projects, differences among parties on one or other aspect are bound to happen, which may or may not convert into full-blown legal battles. Upon onset of a crisis, contracts are the first thing to be pulled out of the closets and to be read line by line to the advantage of each affected party. In case everything goes well, no one will read the contract. However, in case of an unexpected event, all businesses will expect that a remedy for such an unexpected event should be provided in the contract. Hence, it is quintessential to draft the contracts with exemplary terms that protects the rights of the parties and fosters business relationship for symbiotic growth. For this reason, a well-drafted contract is otherwise termed as Vedas for a project or commercial transaction that stipulates ethical way forward and balanced remedy for the malaise of these stakeholders. Friends, as we all know, the commercial contracts and agreements are considered to be the heart of the business. Hence, the heart of business needs to be cautiously drafted with proper legal vetting as well. Any loophole in a contract and agreement can bring unforeseen business liability. The saying, a stitch in time saves nine, is perfectly applicable when it comes to drafting of the commercial contracts and agreements in India. Also, friends, gone are the days when in the mid-19th century, the popular American talent agent and deal maker, Paul Laser, who managed several well-known Hollywood stars of his time, had famously quoted, "I have no contracts with my clients. Just a handshake is enough." So now I hand it back to my colleague Jamie to introduce our speakers and look forward to an interesting and enriching session. Thank you.
Thank you, Mr. Nath. I think for setting the tone absolutely right for today's session. We are pleased to welcome our speakers for today, Mr. Prashant Mara, who is a partner at BTG Legal. Prashant specializes in investigations and dispute resolution and heads the disputes and business crime team at BTG Legal and has been helping clients manage risk and protect their interests for close to 20 years. His clients are seen across the range of sectors, including technology, energy, defense, automotive, aviation, industrials, pharma, and chemicals. Prashant was previously co-head of the India group at Osborne Clarke in London and Cologne, and prior to that ran the India desk of a Franco-American firm in Paris. Our second speaker for today is Mr. Parveen Arora, who is a partner at BTG Legal. Mr. Arora has over 25 years of rich experience in many roles, including the legal, commercial, regulatory, and management activities of large infrastructure, power, renewable, and manufacturing companies. Apart from his specialization in commercial contracting for the energy, renewable, and infrastructure sectors like high value and capital intensive EPC, turnkey, O&M contracts, he has also in-depth expertise in handling litigation, financing, project construction, and regulatory matters. In the past, he has led the legal and secretarial department of a London Stock Exchange listed entity, which was the first Indian company to explore the coal-bedded methane from a large government awarded block, and it also got the global depository receipt listed on the AIM and LSE. We are very pleased to have both our speakers join us, Prashant and Mr. Arora today, and we eagerly await to hear and learn from you.
Thank you, Jamli.
Thank you.
And thank you very much also to Mr. Rajesh Nath for giving us this opportunity. I know I have to put the presentation up, so if I can get the sharing rights for the presentation, please. And if everyone can please bear with us for 2 minutes before we handle this technology bit. Apologies for the pause. Jamli, would someone be able to give me the sharing rights? Thank you.
Yes, I think Manohar has. Prashant, if
Yes.
you could kindly check. Yes.
Great. Is the presentation visible?
Yeah,
it's visible.
Yeah, Prashant, it's visible, but if you could just move to the slideshow mode, that would be better.
Is this better?
Yeah. Yes, perfect.
Okay.
Yeah.
Great. Thank you very much. Good afternoon, everybody. And I know it's a Friday afternoon, so we'll try to keep this crisp as well as interesting. You have, as Rajesh already pointed out, a unique situation today where contracts are being looked at more and more closely. And we have Mr. Parveen Arora, my colleague, who has, as you saw from the presentation and his profile, he has rich experience in this field. So the order of play will be that we will take each slide and clause, and Mr. Arora will start off with his views. And if I have anything else to add, I will step in and provide my views, because my views come from more a court practice, how these contracts and these clauses are interpreted in the court. So between Mr. Arora and myself, I think you will get both aspects, the court aspect, but also equally the negotiation as well as the drafting aspect. So without further ado, Parveen, maybe I'll hand over to you with the first slide. And please, Parveen, just indicate to me when you want me to move the slide, and I'll move the slides. Over to you, Parveen.
Sure. Thanks, Prashant. Thanks, everyone. Good afternoon, good evening, and good morning to everyone based on your timings in your respective countries. We are talking about infrastructure contracts today, mainly EPC of that. Infrastructure is a very important sector for every economy. You can say that country's growth or economic growth happens two ways only: one, finance and insurance, and other through infrastructure. And infrastructure projects, you must have seen a very, very huge scale, like airports, power plants, everything is being constructed on to improve the infrastructure. There are three segments mainly when infrastructure comes into: supply and install, EPC, and turnkey. Supply and install is only when you supply your machinery and go and install at your site, at your owner's site. EPC, where all scope is done except mostly land and approvals. And whereas turnkey includes everything, like you have to do everything for that project and handing over directly to the operation people. So we will make most of the, you can say, 70-80% projects are being done through EPC. So we will be talking about EPC only, since it involves many stakeholders, service providers, suppliers, machinery suppliers, government, local third parties, everybody is involved, and it takes very long to execute, to conceptualize, to execute the contract. So disputes are bound to happen. We cannot do away with the dispute. It is just wishful thinking that there will be no dispute. But to a certain degree, by including, by carefully drafting and including certain clauses, we can reduce the quantum and intensity of the disputes. So, Prashant, can we go to next slide?
Yes. Before we proceed to the next slide, just one point.
How can I make it large screen? This is coming as a very small window. Can anybody guide?
On your touchpad, if you expand it, the screen will get bigger, so you can do it on your own laptop or your notebook.
Right. So while Parveen tries to get that sorted, what I would like to add is, because a lot of the German companies that we have seen are mainly into engineering products and services. So in an EPC contract, it's also important to understand where the value lies. There are parts of the contract where the value might be higher in one particular part, either engineering or procurement or construction, depending on what kind of an EPC we are talking about. In most cases, what we find is engineering and procurement form about 70 to 80% of the value of the contract, with construction forming maybe 30% of the value of the contract. But because these are all structured in a waterfall mechanism where one follows the other, you can't actually carry out your supply chain without the construction being on site being done properly within the milestones. And because there are multiple parties involved, as Parveen rightly said, the scope for disputes becomes more and more. And the more number of cooks you have, the more chances of the broth getting spoiled, as they say. Therefore, in an EPC contract, what we have seen is dependencies increase, and therefore the liability or the potential for disputes increases, and the supplier of engineering goods or design services is the one that has the most risk, because most often than not, the EP part of the EPC is the most valuable part of the contract. So I'll move to the next slide. Praveen sir, over to you.
So certain aspects definitely need to be taken care during drafting of the contract. But before drafting, before even at the time of conceptualizing a project, people who are involved, like legal people, project people, finance people, they should pay attention to certain things and accordingly take this project. First, we always tell people that understand your business first before going into contracting. Sometimes particular segments are like legal people, mostly they will focus on legal things only. That's not the ideal situation. We should look into overall business, that what is our capability, how our organization works, what is our technicality, what is the expectation. Like certain organizations say that we will not work less than, for example, 20% margin of the project. So once we have all costing in place and at what price we are selling, we will not work less than 20%. And then accordingly, expectation of the organization and capability, technicality of the organization should be kept in mind before going into project. All these things should be considered, and accordingly, call should be taken. Then next is for the particular project, like how commercial terms will work, how technicalities will work, timeline, what should be the timeline, whether we have enough people to perform on time, or we need longer time. It should not mean that your contemporary or competition is able to do in 6 months. You should also be doing 6 months when you don't have manpower, a lot of manpower, a lot of capacity. This depends from each contract. Like you should see that whether what we can do, what we cannot do. Then comes Prashant, can you little bit scroll down? My screen is still coming up. I am not able to resolve the issue.
Right. So I've actually, it's completely full on my screen. So I don't think I can scroll down.
No, just scroll down. I'm saying, okay, you can't scroll down. Okay, sorry.
Let me take over. I think what we could also think about here is the commercial and legal teams have to work together. As Parveen earlier said, there will be lots of lessons learned previously in the pre-pandemic and now during the pandemic. So let's take a simple example. Say 12 to 18 months, there was very less business. Everyone was in cold storage. Projects were kind of in abeyance. And now things are slowly opening up. It would be very, very tempting to just go back and take the same template that you used 2 years ago and say, okay, let's sign the same kind of contract. But during the pandemic, a lot has changed. Your previous suppliers may have suffered. Their creditworthiness would have may have decreased. Your customers may be over leveraged. They may have loans against them. The bank guarantee terms now have varied substantially. Banks are making a huge hue and cry about providing bank guarantees. There may be attrition in your own team or in the supplier team or in the customer team. So please don't assume that all the contractual terms will remain the same post-pandemic as they were pre-pandemic. Even pre-pandemic, we had issues. Now, post-pandemic, I think those issues will increase, and therefore, please, legal team and the commercial team have to relook at quite a few of these commercial, technical issues before you continue using the template that you used to use previously. I'll move on to the next slide.
Yeah.
Praveen sir, can you see it now?
Yeah, I can see it now. One more thing that you must see, you should, before going into the project, you must have a workshop kind of thing with your internal all stakeholders to see that what we have done in the past and any lesson can be learned from the past so that it can be improved in the future. Now, during contracting, now we come to the next phase, during contracting and negotiations. Generally, when we draft our contracts, we feel very happy and we think that there will be no dispute because we are doing it very clearly. Or we are, when we do negotiations, sometime like it goes all in a big saying in banks that all bad decisions are taken in good time. So when we do negotiation, sometime other party will say, don't worry, this is a small thing, we'll do it. But consider every scenario that there can be dispute. Like I'll give you a small example. Let's say that your trucks have arrived at sea. When trucks arrive at site to deliver machinery, you have to write that delivery note has to be signed within 2 days. Now, sometime other party will say that, oh, our people will not be there. Let's not put any timeline. Let's just keep the delivery note will be endorsed. Now, this can raise a big dispute that when and how long they can take, because this delivery note will be basis of your payments. This will be annexed with your invoice. Until unless you get this endorsed, these kind of things can raise. These are some very, very small things, but can become a dispute during execution. Scope should be very clearly defined. There should not be anything which is left unattended. Either owner should do or you should do. As a supplier, you should do. Scope should be confirmed by your all respective business vertical, like finance, like projects, because they have to execute. Then you have to clearly see that what capabilities you can take, like approvals. If owner says that you have to bring approval, also if approvals are too complicated to bring, whether you have enough regulatory department who can do this. Then in India also there was certain structuring of the contract, like supply contract was different, erection and commissioning was different, operation and maintenance different, and customers were certain time asking for wrap agreements so that liability is at one place. So you have to see this also. You have to take separate tax advice that how you should structure this contract. Most of the like this problem has gone away with the introduction of GST, but still sometimes this practice is being adopted. Last point in this, that you should have list of 2-3 approved vendors like crane supplier, vehicle suppliers, material suppliers, so that when you go and take approval that we are appointing this subcontractor to your owner, there should not be any dispute. He can choose among any one of those 2-3 approved already agreed vendors, and there is no wastage of time or dispute at that time.
Right. I just want to reiterate one point that Parveen sir mentioned, which is these small things. As a disputes lawyer, as a litigator, there are I cannot count the number of organizers, a number of litigation that I have seen arising out of small issues, which the parties, when they were negotiating, thought that never there would be a dispute on the basis of those issues. A classic example is what Parveen sir just gave. The other example I can think of is simply acceptance. If you don't define a particular date in an acceptance or a deemed acceptance, say that the customer doesn't accept and doesn't give you the acceptance certificate for your product, there should be a deemed acceptance in your favor. Otherwise, the customer obligation to pay never arises if you don't have a deemed acceptance clause. So small issues where you have clear milestones, clear deliverables, and clear sign-offs on deliverables are essential. And 50 to 60% of the or even more than that, 70% of the disputes that we have seen arise because these deliverables are not specified clearly or the sign-offs are not specified clearly. Moving on, sir.
Now, we have divided this presentation in 3 sections. First section, we are taking it must-have clauses. These clauses you should have in your contract. First is a clear distinction between effective date and commencement date. Generally, effective date is when you sign your contracts with other party, and this becomes effective. Legal clauses become effective. But your operational clauses, like your start date, should start from the date when certain conditions have been fulfilled. Like on the effective date, nobody will give you advance. They will give you advance after 10 days, 15 days. Your timeline should start from that date. So it is always advisable to include certain conditions precedent in your contract, like remittance of advance, issuance of letter of credit, handover of land. Once those conditions are fulfilled, commencement date triggers in. That is called effective date and commencement date. And all your operational liability should start from commencement date. Then clear, you can say a division of responsibility between owner and supplier should be very clear. It may run into 10 of pages, 20 of pages, but it is advisable to have as detailed as possible scope. It will the only document which will be referred during execution, and first document to be referred when you can say some difference or dispute arises. Prashant, you want to add something?
Yes, sir. I want to add 2 points here. The first point is I have seen a lot of companies, especially German companies, and I don't know whether this is because there is a specific kind of documentation they're used to, but a lot of German companies work on the basis of purchase orders. Now, these purchase orders are extremely dangerous, according to me, in the way that they're structured, because the purchase orders are mainly commercial documents or technical documents, and they seldom contain the effective date, commencement date, and divisions of responsibility. And sometimes they contain some legal terms, but not full legal terms. Now, it is important for all of us to understand that irrespective of what you call it, a purchase order, contract, agreement, EPC contract, whatever it is finally an agreement and a contract under law. Even a purchase order that you exchange between the two parties is a contract. Now, if you don't put all these terms in that purchase order, that means that you're leaving open all the elements that are important and that are not been included in the purchase order. Why I brought that point here is, in a purchase order, you typically have a template format. Maybe it has things like delivery date, price, warranty, etc. I have seldom seen in a purchase order clear division of responsibility. I have not seen the concept of a commencement date at all. This is extremely dangerous, and it brings to courts so many litigation where the lawyers are at a loss because there is no contract terms and conditions that they can use to justify a delay, justify non-performance, or justify a termination or damages. So that's point number one. The second point that I want to make is, see, divisions of responsibility is also going to be dynamic. It cannot be that you agree to a division of responsibility or you agree to a milestone and that remains set in stone. That is probably not going to be possible in especially a dynamic market like India, where timelines keep changing almost on a monthly or a weekly basis. So what your DOR needs is a very clear change order procedure, which means, let us say your milestone gets delayed because the customer has not fulfilled one of his condition precedent of handing over the land. That cannot be conveyed over phone. It has to be conveyed in a proper procedure as specified in your purchase order, contract, whatever you want to call it. Because later on, if the customer says that you delayed the delivery and that had a ripple effect on my commissioning date, that you can easily show this documentation to say that, but you requested for a change order and that change order was what we acted upon. In that change order, you can also prescribe the cost escalation, because in some cases, when there is a change in the milestones or change in the delivery conditions, etc., it could lead to additional costs like demurrage, storage, etc., for you, the supplier, and that is required to be properly documented and to be claimed in the future. And that is where the divisions of responsibility and change order comes. So just moving on, sir.
So next clause is change in law. Very important. You all must be aware about this, that change in law plays very critical role when a law changes or something. From the very quotation date, when you give your first commercials to owner, or you provide your quotation, from that date, this should be your right, that if there is any change in law after, because you are today providing your commercials on the basis of existing law. If it changed, it should be on the owner's account after quotation, because between quotation and execution of contract there may be some difference. But if nothing has changed, then this clause can be included in the contracts also. And change of law can be that introduction of new law, change in existing law, interpretation by courts or some authorities might have changed everything. Like, I'll give you a small example. Like, let's say that you have manufactured a big machine for your customer, and while it was on transition, or while it was on you can say during transport, there was a new law came that machine should be equipped with the aviation light compulsory, otherwise you cannot. Either owner should exempt you from any liability, or they should provide you time and cost to implement this aviation thing also, what new law has come. So this is very, very important clause, and this should not be, you can say, overlapped with the force majeure clause. Sometimes events fall into both categories. Generally, force majeure does not allow you to take cost, but change in law allows you to take cost as well as the extension of time only.
Right, sir.
Then comes force majeure, which is another, particularly considering this epidemic, and everybody must be very well aware now. It was the most ignored clauses. These were one of the most ignored clauses, but now it is most attentive. People are most attentive to force majeure. Now, force majeure clause depends, like definition of it is that a certain event which we were not aware, which is beyond your control, which you could not which you could not foresee at the time of contracting, can happen because of long periods and other aspects of the EPC contract. So force majeure is not to account of any party. It is not fault of any party. It depends that what kind of scope you are having. Like, let's say, for example, you are having only supply and install. Then you can agree for close list of force majeure. Close list mean you will include certain events that these will be only force majeure. Whereas when you do EPC contract, you can have broader list, which we call inclusive list, means force majeure event will be which is beyond our control, including following. Then you put act of God, man-made, non-receipt of approvals, or everything. That force majeure, generally it is parties can negotiate for some cost also, but generally that it is only given extension of time. No cost is given by companies for meeting force majeure expenses. Along with force majeure, you have to also include that effects of force majeure. Let's say that heavy rains have come. Rains have stopped in a day, but its effect will remain for 3 days. So your force majeure claim should be 3 days. There are certain exceptions also, like non-availability of finance, or not able to pay. Those things are not force majeure. There should be certain exceptions also to this. Prashant, you want to add something?
Yes, sir. There's only one point that I want to add here. Force majeure has been very closely looked at, as you said, in the courts, even during the pandemic. And there is a Delhi High Court judgment which came out about in March or April last year, which essentially said that for force majeure to be initiated, you can't suspend a contract due to force majeure, and then when the force majeure passes, you reinitiate the contract, especially if, for example, it's your customer. So as a customer, the customer cannot say, I pay you because my revenues have fallen during the pandemic. That is not a force majeure, is what the Delhi High Court has held. So it's actually advantageous to the suppliers. The suppliers can claim that there was a force majeure event and therefore it got delayed, or the production was shut down when the factories were shut down because of government directions. But the obligation to pay for those supplies remains on the customer unless the contract provides otherwise. So that's, I think, a very important and a positive development as long as your suppliers in the market. But over back to you, sir.
Correct. After this, you should try to take payment security. Like, your payment should be received through letter of credit. Otherwise, every time you have to send your invoice to your customer, who will approve in their own time and then send it to you and they will pay you after deduction certain amount. Now, when you negotiate this LC, you can agree for any number of you can agree for any number of documents. Let's say that you will, with invoice, you will attach a delivery note, you will attach a copy of insurance, you will attach a certain specification of the product or whatever. But once those number of documents have been agreed, then your invoice and document should go to bank. And there should not be any customer intervention once he has completed, like he has signed all the documents, delivery note, completion of milestone, everything. Then they should not have any say to not to pay or delay the payment. That should be tried at your best, that you should get your payment through mechanism of letter of credit without going back to customer for his approvals. And this LC should be given to you along with payment, advance payment, because advance payment can be remitted directly. Rest every payment should come through LC. Yeah, Prashant. After this suspension, you should have this right. Generally, owners keep this right or customers keep this right, but generally you should have this right, because payment has to come to you. Main issue comes like sometime it is written that payment, once you submit your invoice or once payment due becomes due, you will be paid in 45 days. If you are not paid in 45 days, you will issue a notice, and next 30-40 days you will be paid. Now this becomes 2-3 months where you can almost deliver your most of the project, which should not be which should not happen. Mean, if you are not paid from due date within 10 days, you should have right to stop further supplies at least. Or if there is a material breach like land is not available, access is not available, you should have right to suspend. And for suspension, that is you should be entitled. We will come to delay events later on, but you should be entitled for extension of time and cost, because it is not your fault. You are suspending it due to someone else's fault, not performance of owner. The suspension rights are very important. You must have sometime owners push that if they are not able to procure land and if they are not have certain approvals, they can ask you to delay the project. But for that, also you should have a right to claim extension of time and cost.
Nothing from me, sir.
Yeah. Next slide. Then comes limitation of liability. I mean, whatever we are doing, we are business organizations. We are doing so for certain profits. We cannot have unlimited liabilities. You must have this limitation of liability clause in the contract. And we always advise that except indemnity, and indemnity should also be only for bodily injury, death of someone, loss of property. Except indemnity, everything should be covered under limitation of liability. Generally, there are certain carve-outs. May I request to keep on mute? Generally, there are carve-outs from. May I request everyone to keep on mute, please?
Sorry for the disturbance. Please continue. Yeah.
So limitation of liability should only carve out of indemnity. Certain time it is insisted that IPR liabilities or delay liquidated damages should also not be part of limitation. But as a supplier, we will say that you should not agree to this. And owner should also think that you cannot go beyond 100% of the value of the contract. If you keep it unlimited, even if there is no dispute, it can make your balance sheets very, very heavy, because you have to create, as a big company, you have to create provisions in the contract, if in the account, because unlimited liability. So it cannot be kept open. It should always be close to certain limit, but not more than 100% in any case. Then
I can just add on this particular point of limitation of liability. The limitation of liability for us litigators is like the final defense. Let us say that there was a warranty claim, and you find out there was in fact a warranty breach, that the warranty that you had provided was not fulfilled. And there is no mitigating circumstance that you can say that the customer misused it or used it with a third party product, or interfered with the warranty rectification. In that case, limitation of liability becomes a safety net, because you can say that, okay, fine, I'm liable, but I'm only liable to this extent because the contract says so. Therefore, it's extremely important as a fallback final safety net in all contracts. Again, one of the things that I've noticed in the purchase orders is that there is no limitation of liability. So it becomes very important for us to look at the way we are drafting the purchase orders and making sure that some of these must-have clauses are there. Back to you, sir.
After this, defect liability, warranty period, all are interconnected. Everything will start from the defects only. So therefore, defects should be defined very clearly, that what is the defect. It should not be beyond technical specification given for the machinery, plus a scope of services. It should not be, I mean, anything, if you're lacking in those, that is defect. And there are certain exceptions to defect also, like wear and tear, if something has happened due to force majeure, or owner has given it to someone else to service or do cure of defect and all that, then you will not be liable. That will not be called as defect. But otherwise, and if defect occurs, then only defect liability will be on you. You have to whatever period you have given for 18 months, 2 years, or 12 months, defect liability period will arise only from defect. One important point in this, sometime you are insisted that if defect arises, how long you will take to cure it. We always suggest not to put any time limit, because it's very difficult to say that how long you will take. We are not saying that you will take longer than required time, and it is prejudicial to customer also. It is not right in their favor. But you also cannot give time, because certain part which is not available today may be available after a week or 10 days. You can always give time to start curing of defect. You can say that within 48 hours of notice of defect, we will start the process of curing the defect. But you cannot say that we will do completion of cure of defect within 1 week or 10 days. It should be your internal, you can say, kind of reputation that you will not leave any defect unattended. But at the same time, it's difficult to give any time limit to defect.
I just want to add one thing. I'm conscious that we are running out of time, but because there are a lot of German the contracts, sometimes a lot of contracts I've seen are also governed by German law. Now, in German law, there is a concept of guarantee, which is different from a concept of warranty. Guarantee under German law is a no fault liability. That means that if you guarantee something under German law and you write the word guarantee, that means that irrespective of whether the customer was at fault or some third party was at fault, you become liable for that defect. In India, there is no concept of guarantee. There is only a concept of warranty, which means that you have to contractually provide for that warranty in the contract, or the Contract Act, Sale of Goods Act warranty comes into the picture. So if your contract is being governed by German law, then obviously a German lawyer should take a look at it. But please be extra aware of these words like guarantee, which in German law means no fault liability. Back to you, sir.
We have already spoken about indemnity. Indemnity is something which you are not aware today, or which has not been disclosed to you, something, and any liability arises on that account. Let's say that I am selling some property and I have disclosed, I am asked to disclose all litigation, but I have not disclosed to litigation. I have to indemnify them that I have disclosed everything, and anything arises out of this, I'll be liable. So indemnity is mainly in the contract for mainly 2-3 things, like if due to your negligence, due to your willful misconduct or default, you will come if loss to any property, or injury to anyone, or death of someone, you will indemnify the owner. Beyond this, IPR indemnity also we give, but we try to keep that also capped to certain percentage of the contract, that it should not be beyond that. IPR is not also in our hand, because infringement can happen unintentionally also. So indemnity should be limited to certain points only. Same thing about IPR also. IPR is your, you can say, fundamental basic asset to do business, and it gives you freedom to sell your products in the market. In India, IPR goes with the product. It cannot be separated from the product. And as a customer sells to someone else, IPR will go with that, and you can give right of IPR to in relation to that product only, that you will use this IPR for operations, maintenance, and repair of the product, but it cannot be separated from the product. And IPR is being very important. You should be very careful in drafting this, because all rights are with you. And if there is any joint development of the IPR during execution, that also you should agree today that how that will be, you can say, taken care. Both you will be owner, but that should be agreed very upfront, that we will pay the fee and we can utilize that throughout the world, because ultimately it's your business. You must exclude consequential damages. Like some default has happened, you cannot be liable for consequential indirect damages. Let's say that you have broken some part or some defect arisen, you can have liability to repair that part, but not that how much revenue owner should have generated if default has not occurred. So you should carve out very clearly that no party, either you or owner, will not be liable for any consequential damages.
I just want to react on all 3 points very quickly. Indemnity, one thing you have to keep in mind is that it is a independent contract. That means that the moment you have an indemnity in your purchase order or a contract, even if the other provisions of the contract are held invalid, or you can dispute upon the applicability of the other parts of the contract, say for delay, etc. If there is an indemnity provision, the courts have held that that is an independent contract and therefore it will be enforced. Therefore, an indemnity provision is quite dangerous for a supplier, and you have to really carefully restrict it, as Parveen sir said. Second point about intellectual property rights is, again, it's quite surprising to note that many of the contracts, purchase orders that we have seen do not contain a specific restriction against the customer from reverse engineering. As Parveen sir said, the IPR in India flows with the property or with the product. But if that doesn't mean that they can do anything they want with that IPR. They can use the IPR to the extent of operation of the product, to the extent of repair of the product, but there should be a specific restriction and a reservation of rights against reverse engineering and anything else that they cannot do with the IPR. Finally, on the consequential damages and losses, it's very important for suppliers of engineering equipment to know that sometimes their equipment is quite critical to the operation of the plant or the operation of the entire infrastructure project. Therefore, if you do not exclude the consequential damages, the liability that may come upon you could be quite heavy. We have seen instances where we have helped some of our customers with nuclear contracts, where the liability can go into even amounts that we cannot really predict how much would be the damage caused. Therefore, it's extremely important to have an exclusion of consequential damages. So next, back to you, sir.
Now, second section, we are now reaching to second section, that certain clauses which make your position strong if dispute arises. As Prashant said earlier, deeming provision. Deeming provisions are very essential in the contracts, particularly from supplier side. Since you are going to someone else's site, you are working on someone else's site, there should be some certain deeming provisions also. Let's say that you are supposed to deliver on a particular date, but you are not able to deliver due to non-availability of access or non-readiness of the site. Then your trucks cannot keep on standing at the border, that awaiting that things will be clear. After certain time, after such delay, of course you are entitled for delay event, which will entitle you for cost and extension of time. But you cannot keep on waiting for your milestone payments. Since your goods are ready, you are ready to deliver. After certain time, it should be deemed to have been achieved that you are delivered. Whereas actual achievement of milestone will remain with you without any dispute. That you have to fulfill that condition, that you have to actually deliver also. But certain time it should be deemed to have achieved, and you should be entitled for payment, either full or 90%, 80%, 75% of that milestone. And after that, let's say you are delivered, but you are not able to commission for next 6 months because land is not available or site is not available. Then you should have your payment at least. And then once all things are ready and all the things you can go and install that also. And even if it is a longer period of delay, your warranty will also be reduced. Like earlier, when product was new, you were given 24 months warranty. But if 6-month delay has already happened and equipment is lying on land, you can always negotiate to reduce your warranties also to 18 months or 12 months. So deeming provisions are very, very helpful if you have in your contract, if you will not be stuck with your payments. Second point is that try to take front-loaded payments. Front-loaded mean heavy part should come to you before at the time of delivery. We generally take thumb rule of 70-75% payment should come to you at the time when you deliver your product. Your cash flow should not be negative at any time except you can say 1 or 2 months during your manufacturing. Otherwise, it should remain always in positive. Otherwise, contract after the contract, when you will calculate your financial, it will not be very favorable. And you should not agree for set of rights. Set of rights mean owner should not be allowed to deduct certain money. If he if he like if you owe some money to him, he should raise invoice for them. You should raise invoice on them. It should not be crossed that we have to pay 100 rupees. We are deducting 10 and giving you 90 because we have to take 10. That creates a lot of confusion and gives unnecessary right to owner to deduct monies. Prashant?
Nothing from my side, sir. I think we're running out of time, so I'll move to the next slide.
Bank guarantee and bonds, you will be asked to give bank guarantee for advance, performance and all that. So be careful when you agree. First effort should be not to give any bank guarantee. It should be limited to corporate guarantees. But if you have to give, please ensure that your bank guarantee, advance bank guarantee, keeps on adjusting with every milestone. Or in the first milestone, it should be adjusted and returned. But if not returned, then proportionally it should be reduced. Performance bank guarantee should be given when you execute, when you complete the project for defect liability period for limited period. For a, let's say the defect liability period is 24 months, you can give for 12 months or 18 months. That will be, you can say, give you some strength if dispute arises. Then how to avoid disputes? Now these were the early stage assessment and planning, as we have discussed earlier also, that you should have very clear planning that how we will escalate, how will risk assessment and risk allocation, who will take this. Then we include a clause delay events. Like, as I said, that you are going to perform at someone else's site, you should have certain list of events which can delay your performance, and for that you should be entitled for extension of time and cost. Let's say access is not available to the site, land, non-readiness of land, or third party local villagers come and demonstrate it on the road, they don't allow you to go. These are all delay events which will delay your project. You should not be liable. If you don't account for these, you will be liable for liquidated damages, but without any default of yours. So you should carve out that whenever such delay event happens, you will be entitled for extension of time and cost. Concurrent delays, it's very important, generally is not carefully looked into, but very important clause. Like, let's say that two delays run concurrently, one delay from your side, one delay from your owner side. Let's say that he has to make a road to access to the site. You are delaying of delivery and he has also delayed, but for his delay you should claim extension of time and cost, whereas for your delay you are already liable for liquidated damages. They are not liable for anything. So concurrent delays plays very crucial role. Both parties will try to you can say negotiate on this, that whether shorter delay should be taken into account or longer delay should be taken into account. From your side, a delay which any delay which entitles you to extension of time and cost should be taken.
I just like to come in here with one statement. Delay is probably the biggest cause for disputes in India that we have seen, at least in the recent past. And these delays can occur not only from the customer side, but also third parties. For example, let's say a expert who is supposed to come and test the equipment, and he delays. That causes a further knock-on delay for your delivery items. So you have to make sure that the delays are covered in such a way that, as Parveen sir said, any delay that is beyond your control should get you an extension of time and cost. So back to you.
Sole and exclusive remedies in your contracts, every remedy is given. Both parties are taking very informed decision to enter into contract. For delay, liquidated damages are there. For non-performance, termination, suspension are there. For IPR infringement, there are IPR indemnities. So you must write that whatever written in the contract or whatever written in the specific clauses, those are sole and exclusive remedies and exclusive rights of the customer only. They should not go and file. Let's say that you have given liquidated damages to customer for delay of 5 days or 10 days. Then customer should not go and file a case that I have suffered so much of loss, I should be given more. So it is after every remedy you must mention in the contract that these are the sole and exclusive remedies for you, and remedies for us and our exclusive sole and exclusive liabilities.
Nothing from me, sir. Last slide, I think.
So, and further during execution, you should definitely your project people will keep on giving daily reports, weekly reports, every thing is logged in. But if project is big, you can have these remedies also, like you can have a neutral facilitator at site who participates in all the meetings. He's neutral person being paid equally by both the parties. They participate in all the meetings, and when dispute arises, they give a neutral decision. Parties are not bound by that, but that can be useful when your dispute arises. Dispute and bigger project dispute resolution boards are there, where they remain, you can say, privy to all the correspondence, all the reports, and if dispute arises, they can give their decision. On-site neutrals, fact-finding investigators also you can bring in if if some differences are arising. Then you can take it specially advisory also. Then there is a system of mini trial also, like both legal counsel of both sides, they present their case to a third neutral person and they decide. So that these all measures are not to stop the work of site, not to stop the work of project, but one small aspect can be decided there and then you should have very clear dispute resolution and termination clauses, so that you should not decide on forum and all that. You should be very careful that how much cost you want to spend, how quickly you want decision. Then there is system of hybrid arbitration clauses also, because let's say there is only 5 lakh dispute, you would not like to appoint 3 arbitrators and decide on for months. There should be some mechanism of hybrid also, that up to certain level we will not go to arbitration, after that we'll go to arbitration.
I just want to add, and that's the end of our slides, and then I'll hand over back to Jamli and Rajesh. If when a dispute arises, if the senior management gets involved, or if there is a neutral facilitator or some sort of a mechanism to handle those disputes then and there, as Parveen sir said, 70 to 80% of disputes get solved right then. It will not come to a court level. What happens, and what we have seen is many instances, it goes through an it doesn't go through an escalation procedure. It suddenly blows up because the customer loses patience or the supplier loses patience. And then when it comes to formal dispute resolution, lakhs and lakhs of rupees are spent. Then they go into a negotiation where the senior management talk to each other and sort it out. If that negotiation had happened before the arbitration or litigation was kicked off formally, a lot of savings would have been there. So I think the escalation mechanism, mini trials, is extremely important. And that brings us to an end of this conversation, where we had outlined the clauses that were important and for minimizing or avoiding disputes. We are also hoping to come back and talk about what happens when actually a dispute arises, but that's something that VDMA will, I think, take the lead on and let us all know. Back to you, Jamli and Rajesh, and apologies for running over a little bit of time.
Thank you, Parveen and Prashant. I think a very, very interesting presentation. In fact, we had a full house, and we still have a full house. Many people have been unable to join because we have exceeded the maximum limit. And to be very honest with you, the number of questions that have come in, we won't be able to. Otherwise, we would need another 1.5 hours to complete all the questions. So we will take some questions quickly, Prashant and Parveen. So maybe I'll start with the first one. This is regarding concurrent delays. It is always a matter of debate. Payment delay from client and equipment delay from contractor. Okay, like payment delay from client and equipment delay from contractor. How to frame contract laws so that client's delay is not how to frame contract laws.
Yeah, I got this question, Mr. Rajesh. Look, fundamental thumb rule is that if you delay, you have to pay liquidated damages. If your customer delays, they don't need to pay any liquidated damages. So you should claim, if customer is delaying, definitely they have to pay you default interest along with the payment, and that delay period should be considered as your delay event, which should entitle you to extension of time, irrespective of your delay. If you are delaying, you will definitely pay liquidated damages. So you have to manage your contract in a way that delay event, which is entitling you to delay event and entitling you to claim extension of time and cost, that should be considered as delay event. you should pick that delay only.
Just to add, I think one of the things that you can do is to cut this cycle, is to put a deeming provision, which basically means that if the delay event that I am causing is, being in turn caused by a concurrent delay of somebody else. Let us say they have not paid, and therefore I am not therefore delivering. That means that there should be a deeming provision to say that that is a default on their side, and therefore I am not obligated to then supply despite payment delays being made on the previous milestones. My delay is then excused because it's a consequence of the customer's delay in obligation to pay.
Right. Thank you, Parveen and Prashant. Coming to the next question. In case limitation of liability clause is not written in the contract, so whether as per Indian law, is it limited to 100% of the contract or unlimited?
It's unlimited, but there is a concept of there is a case called Hadley versus Baxendale, which is a very old English case, and that provides a test for what can be claimed as damages or not. So if it is damages that are directly related and the parties knew that such damages could have occurred if the breach of contract had happened, those damages are claimable. So it cannot be like US punitive damages, 5 times the amount of the contract, 20 times the amount of the contract, etc. But for example, if there is a possibility that the supplier knew that because my machine broke down, there could be a liability for the customer of X thousand euros or dollars, that becomes a claimable amount. Parveen sir?
Yeah. No, I agree with this, Prashant. Nothing to add.
Then coming to global contracts, in global contracts signed, which law and venue should be considered from Indian contractors' point of view? Also with the point of view that laws which is somewhat similar to Indian law and having less costlier litigation costs.
Parveen sir, you want to take the, or shall I go ahead?
You can take it. This is more related to disputes.
Sure. So I think there is no, unfortunately, there is no jurisdiction where the litigation cost is low. That is the nature of the beast at this point in time. But where I think you can be slightly more efficient is arbitration. And if you choose arbitration, and if you choose, say, Mumbai Court of Arbitration or Delhi International Arbitration Center, which are attached to the courts, and stay away from 3-panel arbitrators. Try to stick with 1-panel arbitrator, and there you can control the costs to a large extent. Now, coming to the first part of the question, which is global contracts. See, as always, when you're based in India, we would recommend that you go for Indian law as the governing law, because you are more familiar, the courts are more familiar, the arbitrators are more familiar. But if you are forced by the customer to go outside of India and choose a governing law outside of India, then you probably the closest you can come to Singapore or UK, which are closer to Indian law principles. But at the same time, you still have to hire lawyers there. You still have to pay for arbitrators there and get relief there. German law is not a bad set of laws. You just have to make sure that before agreeing to any law that is non-Indian, you should go to the jurisdiction of that country and get a lawyer to vet those clauses.
Right. Thank you. Then there's a question regarding force majeure clauses. Why is it preferable to have an exclusive or a closed clause in the case of supply and install agreements? Then from a supplier's perspective, shouldn't an inclusive clause always be preferable?
As I said, that this depends on the scope. Like if bigger scope is with the other party, you should try to have inclusive list. Like if you're going only for supply and install, then you should have all rights. You don't need big force majeure clause, because other party will take advantage of that. You need only for your own scope of work, you need only close list. That if somebody is sitting on the road or access right is with the owner, then that should not be force majeure. You should try not to have that force majeure. So when your scope is narrow, you should have small list of force majeure. When your scope is very wide, you should have bigger list of, you can say, inclusive list of force majeure.
I just want to add here, Rajesh, to what Parveen said. I think the origin of this question is needs to be properly examined. One thing that we should keep in mind is force majeure means you will not get paid. So as Parveen sir said, if you have a very broad force majeure clause and the customer takes advantage of it, that means that you're not getting paid. So instead of a force majeure, you should have the delay clauses, as we have kept saying, which is a alternative to the force majeure, where you can say if the delay is caused by the customer, then that should be compensated to the supplier. And the real force majeure clause should be restricted to real force majeure events where genuinely there is a possibility that the contract will not go ahead, and therefore you can take the risk of not being paid at that time.
Yeah, just add one more line in this. Let's say, for example, you are doing supply and install only and no approval in your account. Then non-receipt of approval should not be a force majeure. That will not be advantageous to you.
Then can we qualify a COVID disruption and a change in law owing to government notifications putting actually by where the government is putting restrictions?
This is a very controversial question these days because your first try should be to take change in law because government issuing notification, but most of the government notifications are recognizing it as a force majeure only. Whenever it is coming, they are specifically writing that this is force majeure. Let's say that you have taken contract from government and government giving extension, they are specifically writing that you should not claim any expenses for this. So broadly, it will be following under force majeure only. As far as drafting of clause during this force majeure, you can include something like when you write epidemic, you can write in brackets COVID-19 also, including COVID-19. Or you can say that if this variant, today's variant changes to some other variant, then it will also be a force majeure. Prashant?
Nothing to add, sir.
Then please advise the contract model to be signed when when two or more parties in fact associate with each other to bid on EPC contract.
Oh, this is a very wide question. It has many answers. I'll just give some options. You can have a consortium agreement. You can have a sub-supplier prime contract, like you are the prime and the other parties are sub-suppliers. You could have a JV, unincorporated JV or an incorporated JV. Now, what is important to understand here is the flow of liability will be very different in each of these structures. And you have to understand, you have to analyze very carefully where you want the liability to lie, who should take the liability, what is the scope of each of the parties. Ultimately, your objective should be that liability and revenues are accounted to in the relevant parties for the relevant scope of work. If you have 30% scope of work, but you take on 70% liability because you're a JV partner and you become 70% JV partner, that is not going to be a good risk management exercise. Similarly, if you have 70% scope, but you take on only 50% or 60% of the payments coming to you, and you're dependent upon somebody else paying you for the remaining 20% because the money is routed through that entity, that again is not an efficient way of doing it. So it's a very broad question. I think we can have like a separate conversation on this, but I think there are various structures, tax, liability, scope. This needs to be looked at before you opt for one particular structure or the other.
Right. Then Prashant or Praveen, are contracts different for material supply and services in engineering sector?
Generally, before GST, these were kept, if I understand correctly, the question is that can supply contract and service contract be different? So
Yes.
before GST kicked in, there were supply contracts were separate because they were attracting 5% duty, whereas services contract were attracting 18% of service duty. So if as per law, if you mix those, then highest duty was applicable. So to avoid that, companies were doing that supply will be separate, but erection and commissioning and operation and maintenance will be separate contract. But then at the same time, everyone was asking for a wrap agreement so that they can fix your liability at one point. That was also not a good practice to adopt as far as tax is concerned. So with GST, all those problems have now taken care because the laws are very clear and taxation slabs are very clear now. So you can have one contract also, two separate contract also.
There is one more way, Rajesh, that I want to step in that you can interpret this question. You can also, maybe the question also means, are the provisions different in the contract? What you agree? Largely, the provisions remain the same. The concepts remain the same. But yes, there will be differences if you are supplying material versus you're supplying services. For example, warranties will be different. Your services warranty is different from your product warranties. Similarly, defect liability will be different. How do you remedy a defective service? There is no way of rectifying a defective service, right? For the same, so it's a cost implication for defective remedy in the services. So yes, there will be 30-40% or 20-30% deviations in the terms depending on whether there are services contract or supply contract, but the concepts pretty much remain the same.
I think this is also a very interesting question. Purchase order are templates issued by the customer. As a supplier, what can we do to add clauses like limitation of liabilities? As in most cases, the customer states that it is difficult to amend predefined templates.
Yes, and unfortunately, this is a problem, and I'll answer and then maybe over to Parveen, sir. I think you have to, companies, it depends on negotiating position of the companies. If the companies are, in a position to basically, if it's a large value contract, for example, if the companies are in a position to push back and say, no, this is what we need, and we will add an addendum to the purchase order, which prescribes or specifies what the terms and conditions are, I think you should push it. Sometimes what happens is that the customers usually say this in the first instance, but if you push back, then they'll say, okay, fine, give me 5 top clauses. I'll include that, but nothing more than that. So you have to negotiate this, and it's up to the commercial teams to actually push for this. We have seen a lot of times commercial teams coming back and saying, no, we cannot do this. Actually, we end up negotiating against our own commercial teams more than with the customer. We try to tell them, you go and negotiate at least, and then see if it succeeds. So it's a question of trying and making sure that that happens. Parveen, sir?
Yeah, that's perfectly totally depend on you can say bargaining power of parties, that how you can negotiate and what level you are. Like if you are at receiving end, you will not be able to negotiate this. But this is also a problem of disconnect between legal and commercial people, because standardized contracts are being pushed through commercial people. They don't understand and they don't want to go back to legal to get those changed. Otherwise, limitation of liability is good for both parties actually.
Correct. I think that's an important point, Rajesh, just to come in. I think the customer should also be made to understand. Sophisticated customers already understand this, but you should also try to make them understand that the contractual clauses are better for both parties. I think right when you started off, Rajesh, you said that a balance should be achieved. That's absolutely right. A contract cannot be one-sided. Neither should we, the suppliers, try to get upper hand in the contract, or neither should we, the customer, get the upper hand, because the contract is a living document where both parties have to execute and live under the contract. It's like a marriage. You have to compromise with each other, right? So to that extent, I think if you make that clear to the customer, saying it is beneficial for both parties, sophisticated customers will understand to an extent.
And just to give one more line, to add one more line, the more complicated contract will be more difficult to execute for both parties. It is not that during negotiation you just push for your terms. That's not advisable at all to any party. If it is done for commercial purposes, it should be simply a simple document and understandable document. Sometimes I have seen that people push a lot for impractical clauses also. Let's say that for delivery note, I'll take 15 days to sign, and then for payment, we'll give you in 45 days. Those become very impractical, then difficult to execute.
I think one last question we can take, although I think it is somewhat similar nature. the customer doesn't want to accept the difference between principal company and Indian subsidiary and wants to transfer the liability, how to differentiate the boundaries while supply contract from principal company and service contract from the Indian company.
Parveen, so this is probably going back to your wrap concept. Maybe you can take this.
Yeah. Look, there is a lot of dynamics in this also, because generally they constitute a new company, and every foreign company wants to take project through a newly incorporated companies. Then it becomes difficult, you can say, to fix liability on a company which does not have anything in hand or any assets of previous business records. And if supplies are being done from outside, then you have to carve out certain clauses which can make their, you can say, holding companies also liable, if I understand questions correctly.
Yes.
Just to add there, Rajesh, I think you can also enter into a contract between the parent and the subsidiary, where the parent then backstops the liability of the subsidiary. So what happens is both the parent and the subsidiary enter into one contract with the customer, and the customer doesn't make any distinction between services and supply. It's the same liability for the customer. They can go after the parent or the, but internally between the subsidiary and the parent, there can always be a indemnification and carving out of the liability to say that the Indian company will only be liable for the service component, and the foreign company will only be liable for the supply component, and they will cross indemnify each other. So if the customer sues the Indian company for the supply component, the Indian company is liable, but there will be a backstop indemnity where the foreign company will indemnify the Indian company.
Okay. There are, in fact, a lot of questions still pending, but I think we'll have to take a hard stop. So we will share the questions, Prashant and Parveen, with you, the remaining questions. And would be nice if you could reply to those, and then we will send those to the participants. In fact, I would like to thank both Prashant and Parveen. I think excellent presentation and very good discussion. As you could see from the number of questions that the participants have put up, we had really a huge number of questions, and myself and my colleague were pretty busy noting down the questions, writing down the questions. So I think it was a very interesting session, and I would also like to thank our members. We had a very good participation, in fact, houseful participation, and in fact, on behalf of VDMA and BTG Legal, I would also like to apologize to many of our members who could not join because the platform became full within 3 minutes. So after that, we were receiving a lot of calls. Many of the members were unable to join this interaction. But thank you, everyone, for taking out time and joining the interaction. And what we can see from the comments also coming in, people have really valued this interaction, and there was a lot of learning for the participants. So again, on behalf of VDMA, thank you, Parveen and Prashant. I think it was a very enriching web seminar today, with a lot of insights that you have given, especially on the contracts, formulating contracts, and the do's and don'ts. And maybe I'll just close it with the last phrase from my side. It is always advisable to do drafting and negotiation with utmost care, and by taking all aspects into account, because circumstances as envisaged at the time of contracting may not remain same during implementation of such projects. So thank you friends. Stay safe, everyone. And as mentioned, we will share the remaining questions. We will request BTG team to reply to those, and we will share with the participants. But thank you, everyone, for joining. All the very best. Stay safe, stay well. Thank you. Goodbye.
Thank you very much to everybody. Thank you, VDMA. Thank you, Rajesh and team.
Thank you. Bye-bye.
Bye.
Thank you.